Welcome. I'm Alexia Hudson Ward, the editor in chief of Toward Inclusive Excellence, or TIE for short, a multimedia blog hosted by Choice, a publishing unit of the Association of College and Research Libraries, a division of the American Library Association. Among the goals of this channel is developing a corpus of resources for information professionals, undergraduates, faculty of all disciplines, campus staff, and administrators at every level, seeking to advance and promote research centered diversity, equity, and inclusion insights on their campuses and within their communities. We are excited to welcome you to this season's podcast series that borrows its name from the higher education academic calendar. Therefore, you're listening to TIE's Fall Semester Podcast. This in dialogue discussion is centered upon a recent Supreme Court ruling in the Andy Warhol Foundation for Visual Arts versus Lynn Goldsmith case. At the heart of this 7-2 ruling in favor of Goldsmith, the Supreme Court agreed with Goldsmith, a celebrated music photographer, that Andy Warhol and the Warhol Foundation violated copyright continuously by displaying Warhol's reinterpreted artwork based on her copyrighted photograph of music artist Prince. The Supreme Court was clear in its majority opinion that the fair use argument from the Warhol Foundation is not applicable. Understandably so, this ruling raised a lot of concerns within the GLAM sector. GLAM is galleries, libraries, archives, and museums, as reinterpreted imagery and artwork from copyrighted images are within many of our collections. So what's next for us and our collections and AI-generated interpretive art that is taking off like a rocket? To help us unpack the complexities of this case, we have two legal experts in this discussion. Katie Zimmerman, the MIT Library's Director of Copyright Strategy, and Jonathan Ban of Policy Bandwidth, who is also the 2017 American Library Association L. Ray Patterson Copyright Award winner. Katie earned a BA in psychology from Rice University, an MLS degree from the University of Pittsburgh, and a JD degree from Harvard University. Jonathan received a BA, magna cum laude, and Phi Beta Kappa from Harvard College, and a JD from Yale Law School. I believe you'll enjoy this compelling discussion about a remarkable case. Now on to our conversation with Katie Zimmerman and Jonathan Ban. Katie and Jonathan, thank you so much for joining us today. We really appreciate you. And I know this is going to be a really great conversation about quite the compelling and interesting case.
Thank you. Happy to be here.
Me too. Thank you.
So I want to start with understanding a little better and also helping our listeners understand a little better. What are some of the major implications of this ruling? And Katie, if you'd like to start, please go right ahead.
Sure. So I'll start by saying I hope the implications are kind of overstated. Like this case is very specific to its facts, and I'm hoping that it will be interpreted in that way and won't have huge impacts, because I don't like the way it came out. But So that is one thing that I'd say about it. One area that I think is interesting to talk about with it is potentially the implications for discussions around AI and copyright that have been coming up recently.
Yes.
So when you're training a large language model, you ingest a lot of copyrightable works. Before this case came out, I would have said that this was clearly covered under prior case law. This is the Google Books and HathiTrust cases. And, once you've done your fair use analysis for the ingest, then you have your thing and you're done, and you kind of don't need to reevaluate every single time. But one of the things that this case might suggest is that you do have to redo the fair use analysis for those downstream uses.
Mm, mm-hmm. Mm-hmm. And you were saying that you don't like the case, and I appreciate that candor. I'd like to hear a little more around what is it that really troubles you about the Supreme Court's decision.
I wouldn't say I'm extremely troubled. I think it's a very specific sort of case
Mm-hmm.
that I disagree with the outcome. I tend to agree with the dissent's reasoning, and I think it's going to have some impact on how we do fair use analyses for things that are quite different from this rather specific situation that this case came out of.
Mm-hmm. Mm-hmm. Yeah, thank you for that. Jonathan, would you share your thoughts around the major implications of this ruling?
Well, I tend to agree with Katie. I think that the facts here are very, very specific, and I mean, to some extent, they're always that way in fair use cases, right? I mean,
Mm-hmm.
it's supposed to be a case by case analysis, and you're looking at the four factors, and here in this case, you're mainly focusing on the first factor, but because it's supposed to be a fact intensive inquiry, it does have, the court really focused on all the peculiarities. There's
Mm-hmm.
always, stray comments, what we call dicta, that conceivably can take on a life of its own. And there's, arguably some of that here. And then I know we'll talk later on about the dissent. I think
Yes.
that also poses its own set of issues. But I think generally I agree with Katie. The court really zeroed in on a couple of very specific facts in this case, which really distinguish it from almost any other situation, and I would say even the artificial intelligence situation that Katie was alluding to. But having said that, again, you know, creative lawyers take decisions and stretch them out of proportion and contort them, and so certainly this decision could be contorted to have negative implications.
Yeah, yeah, oh, absolutely. And Jonathan, since you raised the dissent, I would like for us to pivot into that. Katie had also mentioned it as well. I found the partners on the dissent to be compelling, interesting, and especially around their belief that the ruling will stifle creativity. And so, what are your thoughts about the dissenting opinion and what appears to be an assertion to really protect creative works from those two justices?
Yeah, so if you the dissent and the majority opinion do not match up at all, meaning if you just read the
No,
dissent, you would
right.
think, oh my God, this is the end of appropriation art. This is the end of all 20th century art. Every, museum and library needs to disgorge their collections of not just Andy Warhol, but every art 20th century, or frankly, any artist that's under, that used works that were in copyright, right? Because
Yes,
the
yes.
way the but I don't think I think the dissent either intentionally misread the majority opinion, uh, or was trying to overstate the negative implications of the majority opinion, or it could very well be, the way these decisions are written. You have a draft of the majority opinion, circulated among the justices, and then the dissent, a draft dissent is circulated among the justices, and then they keep on kind of tinkering with it and responding to each other. But it could very well be that the majority opinion maybe really evolved significantly in response to the minority, in response to the dissent. And it could be
Mm-hmm.
that the majority opinion, when it first came out, really, was sort of horrible in the end of 20th century art. And then in response to the dissent, it kind of really narrowed. And so, and just
Okay.
to make that clear, the majority opinion, the facts that Katie and I were alluding to, the majority opinion really focuses and says, look, what is the use that we're talking about here? And it says the
Mm-hmm.
use that we're talking about here is not Andy Warhol's creation of these additional silk screens of prints, the rest of the Prince series. That's not, the court said, that's not what's at issue here. The issue here is the licensing of those images, and particularly one of those images, for use as a magazine cover, right? And so, which is this highly
Mm-hmm.
commercial use, right? A magazine cover, the cover of a magazine basically is intended to sell the magazine. That's its purpose. And it was sort of the use of this silkscreen and the licensing of it for that purpose, that was not a fair use. And in particular because the artist, the photographer sort of sold into that identical market. I mean, she sold images
Mm-hmm.
for magazine covers and for use in magazines, and which is totally different from the art market. And
Right. Yeah.
so the court was really focused on that, about it was about licensing the this Andy Warhol image for the very specific purpose of this highly commercial purpose of a magazine cover. And that is, again, totally different from what libraries and museums and collectors, I mean, they don't
Mm-hmm.
do that. I mean, that's totally different. And but that's the kind of use that the dissent was talking about. And so
Got it.
that's why there's
Mm-hmm.
this complete mismatch. So certainly, and ultimately, what matters is not what the dissent says. What matters is what the majority opinion says. But certainly, you can imagine people will talk about, point to the dissent and say, well, this is what the decision means, and and run with it. And so that's where it could have possible negative implications.
Got it. And Katie, you had alluded to siding more with the dissent opinion earlier on. So can you give your perspectives on this as well?
Yeah, sure. So I agree with John. I hope that the dissent is overstating the impact of this decision. I agree with the dissent that there's something odd going on here with the fair use factors. So another way that this case is very specific is that the court isn't considering the whole analysis. The court is only being asked to weigh in on the first fair use factor,
Mm-hmm.
and that is it. And I think that's having a weird effect here because they are bringing in, there is commerciality as part of the first factor, but it's also part of the fourth factor. And the dissent talks about we're asking the first factor to do fourth factor work here, and I think that is having an effect, and I think that's problematic. I'd be interested in your opinion, Jonathan, on how we ended up with this specific question. I don't know the answer to that.
Well, I think there's even a bigger weirdness, if that's a phrase,
I
about
like
this
it.
decision. So usually when you do a copyright analysis, any kind of copyright case, I mean, the first thing that the plaintiff, the rights holder, has to prove is that there was the copying of protected expression, right? Copyright doesn't prevent all copying; it just prevents copying of protected expression. And and so here, the argument would be that the Warhol silk screen copied aspects of the photograph, of the Goldsmith photograph of Prince. But The district court, and I forget. I think both. I forget over the district court, but certainly the Court of Appeals never looked at whether there was a taking of protected expression. It sort of just assumed that and went right to fair use. And I think actually the
Mm,
district court did as well. But I think the district court assumed that there was a taking of protected expression, but said, but no problem, it's a fair use. And then it went up on appeal, and the appellate court, the Second Circuit, said, no, not a fair use, looking at all factors. And then when it went up to the Supreme Court, they only looked at the first factor, which was sort of decisive in the Second Circuit's analysis. But as Katie alluded, I mean, you need to look at all factors. But the fact that there was never a holding on whether there actually was a taking of protected expression, I mean, that the case has to be remanded to the district court.
right,
It's going back to the district court to determine whether there was a taking of protected expression. And I think in this case, there's a really good argument that there wasn't, because Prince's face is Prince's face. That belongs to him. And
right.
a head-on photograph of Prince, you know, you could have 100 photographers and they do a head-on photograph of Prince. It's going to look like Prince. And then if you do a silk screen based on it, you know, the beard, the mustache, the hair. I mean, all that's Prince. That's not Goldsmith. And then so if you do the abstraction, you know, kind of a Warhol treatment of it, it's going to be, they're all going to look the same. It doesn't matter who Warhol, what reference work he used, any head-on photograph would look pretty much the same. And so much of the, you know, the copyright in a photograph is thin, is the way it's described, and that means that, you know, because the photographer, you know, to the extent he or she is trying to capture reality, I mean, the reality is the reality. So then it's whatever the photographer brings to it. So it's a lot of it has to do with the overall composition. But here,
Hmm.
Warhol didn't take the overall composition. All the stuff in the background and the cropping and the, you know, all that's gone. All that Warhol took is Prince's face. And so there's really a good argument here that there was no copying of protected expression whatsoever, in which case it's like the rest of it is, I mean, you know, the holding is the holding, but I think that there's a good chance that the district court is going to ultimately find that there was no taking of protected expression, which, you know, sort of suggests that none of this really should have, you know, it shouldn't have, they shouldn't have gone, you know, they went down that road because of his sort of mistake in not doing that
Hmm.
first. And to some extent, you know, the Supreme Court probably should never have heard this case. They should have said, no, we're not going to look at fair
Right.
use until until there's a finding of a taking of protected expression. But, you know, they didn't.
Yeah, that's the thing that's so surprising to me, Jonathan and Katie, is that this went to the Supreme Court and that they actually ruled on it. And it's equally surprising to me the vote. It was 7-2. So it wasn't like, it doesn't give the impression to the layperson with little to no legal experience, any idea that this was not a united decision of the majority of the court. And it's puzzling, it's puzzling to me. I know it's puzzling to many others. And when this ruling came out, it sent chills through what we refer to as the glam sector, the galleries, libraries, archives, and museums, because so many of these entities manage and acquire original art and high quality reproductions, some of which land in those organizations' marketing and promotional materials. And so, what advice would you have for libraries and archives and museums to make sure that they're not violating copyright laws given this new iteration from the Supreme Court?
Yeah, I think that's a very interesting aspect of this ruling and an interesting problem that comes out of it. It's not a space that I'm incredibly familiar with. I haven't worked with museums and licensing in that way. But I heard someone speak about it a few weeks ago, and I'm going to apologize for probably mispronouncing her name, but Sriba Quadjovi Quintana at the San Francisco Museum of Modern Art spoke a few weeks ago, and it
Mm.
is affecting how museums are handling this, which I think is an unfortunate outcome, probably. I'm not sure what to do about it. I think like if there's a solution to it, it's caution and perhaps contractual protections that you can put in place, making sure you're really clear when you acquire art. Are there third party materials in it, and who's responsible for having sorted that out?
Yeah, yeah. Jonathan, what are your thoughts?
Yeah, I agree that people are going to have to be more careful, but I think they shouldn't be too much more careful, right? I think they should sort of look at, are they, it really is all about the licensing. So if a museum uh, has a Warhol in its collection, which is based on something else, it shouldn't have any problems about hanging it. It shouldn't have any problems about including it in a catalog about like in a catalog about an exhibit that's sort of analyzing the photograph. But they need to be careful about licensing it for other uses, for the towels and the
Mm-hmm.
coffee mugs. Now, the truth is they should always have been careful about that, but I
Sure.
think they'll be more careful. It could be that they sort of assumed, well, because it's a Warhol, right? That there isn't much of the underlying, anything that Warhol took was a fair use, assuming that there was a protected expression taken, but it was a fair use. And so, therefore, sort of these downstream uses were automatically fair. Um, Again, I'm not sure why they would assume that. And also, in any event, the museum doesn't own the copyright to the Warhol, right? The Warhol Foundation owns the copyright. So,
Right.
yeah, I think they just need to think about it more carefully, and just, or to the extent that there is an artist has, a gallery, an art gallery is dealing directly with the artist, the Warhol Junior or whatever.
Mm-hmm.
Again, that they would need to say, okay, well, if we're going to make these other reproductions, or license it for some other use, we need to be more careful, do our due diligence to say, well, or even if we think it's okay, maybe it's, yeah, why not go back to the original photographer and pay them another couple $100 or something, right? I mean, that's going to be a lot simpler. But I don't know why they wouldn't have been doing that all along. And to some extent, there was, one could say there was kind of a bit of sloppiness here,
Mm-hmm.
given that and I think that that's also sort of an undercurrent in the kind of unique facts that the first print, the silkscreen that Warhol made based on the Goldsmith photograph was licensed, right? I mean, Vanity Fair got a license, paid Goldsmith to make one
Right.
photograph, or one silkscreen, and then Warhol went ahead and made multiple silkscreens. But again, they paid for the right to sort of use it as a reference for one work, and then and so that's why I think once someone knows all the facts, you could sort of say that the court, it's not surprising the court, you were talking about before about 7-2, it's like, it's not surprising that 7 justices thought, she does deserve, the photographer Goldsmith does deserve some extra money. I mean, she was paid the first time, so on what
Yeah.
basis do you say she doesn't get paid for the other times, right? And that just doesn't, it just sort of says, well, that doesn't sound fair. And fair use is about fairness. She was,
Right.
if Vanity Fair paid the first time, then Vanity Fair or Warhol should have paid the second time.
Yeah.
Yeah, one thing that jumps out at me in this opinion is there is that initial like artist's reference, and there was a contract. Like there was a contract that said we're going to pay you a certain amount of money, and this image is going to be used as an artist reference to create an illustration. And I feel like the way this should have gone is, that's a transaction, that's a whole transaction, it's paid for, and then it shouldn't have followed on into this ongoing IP relationship. But it didn't, and I think that's because the artist reference contract included the licensing of the subsequent illustration. Like the contract kind of assumes that this is more of a derivative work situation than a fair use situation. So that suggests maybe that better contracting could help with this in the future.
Yeah, yeah, no, thank you both for those really important points. And I think about something that you two were alluding to earlier in our conversation around fair use and artificial intelligence. As we are starting already to see some real battles emerging between AI artists, fair use, derivative use, etc. How do you see this particular case informing the future of other types of creative works that could be generated in college campuses? Like I hearken back to some of the early days of hip hop music, and had the Supreme Court noodled in that, we wouldn't have some of the classics that we have now because of the issues around remixing and sampling. And that's just one idea that I'm thinking about, as we know, many students and artists and faculty and researchers are now starting to leverage AI in different ways, and create new types of pieces that are sometimes informed by existing works. How do you see, if any, potential impact with this ruling on that aspect of creative development?
Well, AI is a very complicated issue. The copyright issues relating to it are complex, and we're still very early days. I I would say that on the with respect to the ingestion of content, I don't really think that the Warhol decision has any tells us anything about it. It's just so different.
Mm-hmm.
It's sort of like
Mm-hmm.
the sort of the ingestion of content for training purposes. Just it's so far away. And now on the output side, I mean, it could be interesting implications. So let's say the AI generates an image which might be substantially similar to an original image, and then it's going to be, used this derivative is used in some way, and then then conceivably the person who was entered all the prompts, the user who's entering all the prompts into the AI to generate that output would then have to come up with some fair use defense, and so in that case, it could be relevant. Especially if again they were use the image and then put it on a T-shirt, right? I mean, so you
Right.
sort of
Right.
imagine that it's like, okay, do give me a war something in the style of so and so, and then again, there's a whole question about whether that should be considered infringing, but to the extent it's like a very specific, it does cross that threshold into so that the output is substantially similar to the some input, and then but again, it would have to be in the fair use argument. You would it would really have to be, is there some kind of highly commercial use that's different from the original.
Mm-hmm.
Yeah, I agree with that, and I think the most significant part of that is it still has to be substantially similar. Like I think it would. I don't think this case. I think I agree with you. I think this case doesn't change too much because you still have to the output still has to be in potentially infringing. It
Mm-hmm.
would be. I think it would be problematic if that weren't the case.
Okay. Yeah, thank you for that. Because I just happenstantially stumbled across an argument on Instagram between the photographer and an artist who I believe regenerated an image from her photograph and created a new piece of artwork. And she literally says to the person, I just want a Supreme Court ruling on this topic. You need to take this down. And the person said, I'm not obligated to take it down because it's my art. Like, it's informed by an image that, yes, you may have made several years ago, but I, did other elements to it, which then allows me to have imprints on. And it was just fascinating to watch that. I was like, wow, wow, wow.
Yeah,
What is
no,
that going to mean? Yeah, no, go ahead, Jonathan.
yeah, no.
Absolutely. Yeah.
I agree. I mean, you're certainly going to see all. You're going to see. There's no question that there's going to be all kinds of cases that are going to be coming out with all sorts of different fact patterns, and
Yes.
it's going to be really important to separate these different fact patterns. And certainly, if I take someone's photograph. So let's say I take a photograph of another celebrity, let's say Travis Kelce, or Taylor Swift, or I take we had to work that into this conversation, right?
Oh, totally. No, thank you for that.
So let's say I take an existing photograph of Travis Kelce and an existing photograph of Taylor Swift, and then I put them into Dolly or one of these other AI systems, and then I do lots and lots of tinkering, and then comes an output. Yeah, I can see the photographers of the original would want to sue me for infringement, and I could say, all I took was whatever I took wasn't protected, because again, it's sort of like we were talking about before, that Travis Kelce's face is his face, and Taylor Swift's face is her face, and there was no protected expression was taken, and then to the extent there was any, that it was a fair use, right? So you can,
Mm-hmm.
but then again, even that fair use part is like, well, what did you do with the image? I mean, were you selling T-shirts and mugs with it, or were you just putting it on your website as a joke, right, or as a parody or a satire of them or of the NFL for kind of going all in on this, right? So, but
Right.
all I'm saying is, you're going to have lots of cases, and each one is going to have its own factual nuances. In this case, the Warhol decision will be may be relevant for some and not for others.
Yeah. Yeah. Absolutely. A friend said something to me so interesting, and I want us to land on this as our last question. This has been such a great conversation. I could talk to you all for many days on this topic. But they'd mentioned to me how, this is an African American artist whose family is interesting and, in and of themselves trying to kind of work out estate and licensing, etc. But it feels like that aspect was lost in this case, meaning that, where was the Prince family? Where is that estate situated in this discussion around fair use of his image, around profiting off of his image? And the person said, it really just struck them from a DEI perspective that here these two individuals, entities are kind of, duking it out over this image of a prominent African American artist that initially was rejected by popular culture, right? And has a family that is managing his estate, and they weren't centered in the discussion. And I'm just really interested in hearing you all's perspectives around that. I don't believe that the Prince estate was involved at all in this case, but how do we think about that in the context of, images, cultural appropriation of images, looking at this through the lens of diversity, equity, and inclusion? Just how would that fit legally in relation to this case?
Yeah, I think that's a really interesting point. So, to my knowledge, the Prince estate is not involved.
Okay.
But to what we were saying earlier, the thing that Warhol has copied is Prince's face.
Right.
So maybe it would be more appropriate to approach this from a right of publicity sort of angle. But that's not the way it came out.
Yeah,
Right.
and right of publicity is a state a legal doctrine, and about half the states actually have statutes on the book about rights of publicity, the other half sort of protected under common law. There actually is sort of coming out of the whole AI debate. There is a discussion or possibility maybe there needs to be a federal right of publicity to harmonize that,
Mm-hmm.
because you have the possibility of deep fakes and so forth. Or again,
Right.
it's going to be so
Right.
much easier for people to use someone's image for some other purpose in a way they don't authorize it, and so then again, the state rights are very defined, and so it could be that they need to be tinkered with or broadened. But then you need to make sure that it doesn't run into the First Amendment,
Yeah.
because you can imagine all kinds of perfectly legitimate uses, certainly for parody or political commentary that's appropriate, as opposed to sort of like the deep fake situation, which would not be appropriate. I mean,
Yeah.
there are doctrines out there that might help address this, and there is a discussion about figuring out how to broaden those doctrines or plug holes that might become more visible in this context. And a lot of that is, it sort of relates to the whole, name, image, and likeness issue that's come up in sort of the college sports context, where now the
Yes.
the
Yes. Yep.
athletes, right, who have been, completely exploited by the universities for so long, now are going to have the ability to make some money off of their name, image, and likeness. And some of them are making a lot of money from it, but most, of
Yeah.
course, aren't.
Yeah, no, thank you for raising that. What an important point. And maybe perhaps we can revisit that in another discussion, because boy, is that compelling around the licensing of images of college athletes. It's a fascinating topic too, as is this case. And I think we're going to continue to learn more along the days. And you all have really helped us and furthered our understanding around the complexities and the challenges of this case, and really what libraries and archives and museums should be doing in terms of legal due diligence around copyright. So thank you so much for your time today. This was a great conversation.
Thank you.
Thanks for having us.
Absolutely. Thank you for listening to our Toward Inclusive Excellence Fall Semester podcast with Katie Zimmerman, the MIT Library's Director of Copyright Strategy, and Jonathan Ban of Policy Bandwidth, about the Supreme Court's copyright and fair use case ruling in the matter of the Andy Warhol Foundation for Visual Arts versus Lynn Goldsmith. I encourage you to sign up for reminders of new content releases and follow us on X, formerly known as Twitter, LinkedIn, Instagram, and TikTok. Thank you so much for your support. Be well.